Negotiating patent purchase agreements. Negotiation points and common provisions in the sale and assignment of patent rights. There are several documents in the typical patent sale transaction. Many transactions start with a letter of intent. Then the patent purchase agreement is drawn up, and the final step is the assignment that transfers title from the seller to the buyer. Other documents often encountered in these transactions are the declaration of missing originals. This is used when the original filings and assignments have been lost by the seller and cannot be provided to the buyer. An escrow agreement is sometimes used to simultaneously transfer the payment from the buyer to the seller and transfer the assignment of title from the seller to the buyer. A broker agreement is used to engage the brokers and intermediaries who negotiate the transaction on behalf of the buyer and the seller. Confidentiality agreements are almost always present when patent rights are negotiated, and non-disclosure agreements are often signed by the buyer, the seller, and others involved in the transaction. Common interest agreements are used where attorneys are involved and designed to protect the attorney work product, to prevent the information being discovered by an opposing party in a patent infringement case or another lawsuit. The transaction process often starts with the letter of intent that normally identifies the price to be paid, the patent assets to be sold, and key pertinent information on the proposed transaction. Some components of the letter of intent are usually binding, and others are not. Buyers often want the seller to agree to take the patents off the market to provide sufficient time for the transaction to close. This standstill agreement, as well as the confidentiality provisions, are often binding on the seller. However, the buyer is not obligated to complete the acquisition if some information is uncovered in the due diligence process that adversely impacts the value and appeal of the patents. The letter of intent is usually followed by the negotiation of the patent purchase agreement. This takes place concurrently with the delivery of the documents required by the buyer as part of the due diligence process, where the chain of title of the patents is examined to make sure the seller actually owns title to the patents that are being sold. The closing involves the assignment of title to the patents, passing ownership from the seller to the buyer, and the transfer of funds representing the payment. If the patents are subject to a lien by a bank or another lender, an escrow arrangement may be necessary to remove the liens. The escrow means that the buyer can buy after the lien has been removed, and the lien holder can remove the lien after the payment has been received. One issue for negotiation is the payment of maintenance fees during the due diligence transaction period. The seller often asks if the buyer will cover these fees, but the buyers are usually reluctant to pay these fees until after the patent acquisition transaction has been completed. The whole process can take a matter of days, weeks, or months, depending on the number of patents, the complexity of the transaction, and the speed at which the parties are able to respond to requests, agree terms, and turn around the documents. Some representations and warranties are included in the patent purchase agreement. At the minimum, the buyer wants assurances that the seller actually owns the patents that are being sold. The buyer also wants the seller to warrant the status on licenses to the patents. The buyer doesn't want any surprises after buying the patents and discovering that there are one or more licensees that were not disclosed before the transaction was closed. Like a license, the buyer wants assurances that the seller has not entered into any covenants not to sue, which would prevent the buyer being able to assert the patents. Other representations and warranties cover the status and liens and other encumbrances, pending litigation, pending reissue or re-examinations of the patents taking place at the Patent Office. The buyer wants assurances that the patents have not been declared invalid and have not been abandoned. All these representations and warranties are designed to ensure the seller has disclosed all the skeletons in the closet to the buyer, and the seller has not withheld significant facts that would harm the value of the patents being traded. If the patents are being sold by a corporation or another organization, the buyer often asks for assurances that the organization is properly formed and has full rights to sell the patent assets subject to the transaction. Liability limitation is often a topic for negotiation in patent sale transactions. The buyer will often request full compensation if the representations and warranties provided by the seller prove to be untrue, or the buyer suffers losses for some other wrongdoing of the seller. However, the seller is usually reluctant to agree to uncapped liability, and the parties often negotiate to cap the liability at the value of the transaction. The seller is liable to refund the buyer for the cost of the patents and no more, in many situations. There's usually an exception that increases the liability in the case of deliberate misrepresentation or fraud. The buyer likes to retain an incentive to keep the seller honest. The terms of the liability limitation are often negotiated by the buyer and seller. This can be an issue in low-priced patent sales, especially with large, deep-pocketed sellers. If a large company is selling off patents at a bargain price, they're reluctant to sign up to large amounts of potential liability resulting from these transactions. Understandably, these sellers usually require their potential exposure to be capped. Another key topic of negotiation in a patent sale is the license back to the seller. The patent purchase agreement often includes a license allowing the seller to continue to market products containing the patented inventions. In buying the patent, the buyer is acquiring the right to exclude anyone from practicing the claimed invention. With a license back to the seller, this means the buyer can assert against the whole world except for the seller. The seller can't be sued for infringing these patents after they've been sold when the seller has a license back. It's important for the buyer that the license does not include sub-license rights. The patents are virtually worthless to the buyer if the seller is able to license third parties. So the seller cannot retain rights to sub-license. But what about the right to assign the license in case of an acquisition of the seller's company? In patent purchase agreements, this is often a topic of negotiation. The seller wants to be able to sell the company if the opportunity arises, and for the new parent to benefit from the license. The patent buyer wants to prevent infringers from acquiring the seller merely to gain a license to the patents. There are various compromises that have been negotiated in these situations. The seller can restrict the assignment to a similar sized company. After the seller's company is sold, the number of units of products that are distributed under the license is thereby restricted. In other cases, the assignment of the license is restricted to a once-only event. Once the seller has assigned the license to the parent, it cannot be reassigned again to another company later on. Other restrictions are sometimes written into the patent purchase agreement to protect the buyer from the possibility of an infringer buying the seller's company in order to settle a future patent infringement dispute. There are a number of documents that the seller has to deliver to the buyer in the due diligence and closing process. There's the original patent certificates, sometimes known as the ribbon copies, for each patent. Then the seller provides the buyer with the prosecution file histories, including the communication with the patent office during the patent prosecution process. There are the documents forming evidence of the invention's development, patenting, and reduction to practice. If the seller made products, prototypes, product designs, or any other attempts to practice the inventions, these are made available to the buyer. Of course, documents are sometimes lost or misplaced. If any documents are unavailable, the seller agrees to send them to the buyer if they later turn up, and signs a document called a DOMO, a Declaration of Missing Originals. Buyers in patent purchase transactions often ask the seller if the patent sale represents the sale of all or substantially all the seller's company's assets. The reason for this is that under company law, the shareholders of the company are required to approve a transaction that involves the sale of all or substantially all the seller company's assets. The buyer is concerned that the shareholders may challenge the validity of the sale after the buyers paid for the patents, and the shareholders may dispute that the sale was properly conducted. This issue comes up for smaller companies, where the patents represent core assets, and the sale does require approval of the majority of the shareholders. The buyer will often investigate the articles and bylaws of the seller's company to determine what approvals are necessary under that company's constitution. Shareholder approval can be burdensome when there are numerous shareholders and signatures from many individuals are required. The assignment is a document evidencing the transfer of the patents and associated rights from the seller to the buyer. It transfers the rights to the inventions, any causes of action, the rights to extract royalties from infringers, and other rights associated with the patents. The assignment, as it's filed with the USPTO, is on public record, generally does not include the price, and it's normally a concise document that merely evidences the transfer of title and the associated rights. After the sale has been closed, the purchase price paid, and the patent rights assigned from the seller to the buyer, there are some obligations on the seller that continue post-sale. The patent purchase agreement will require the seller to execute any other papers that may be required to complete the transaction. When investigating the chain of title to patents, the title and ownership generally passes from the inventor to the company, then from company to company, in a chain of assignment documents that are signed by the assignor. If one of these is missing, or if the signature is unclear, the buyer may require the seller to produce a new document confirming the assignment was valid. These confirmatory assignments may be required of the seller after the patents have been sold. The buyer may require the seller's inventor and other staff to act as witness in future infringement litigation. In these situations, the buyer usually pays for the services and the time commitment. The terms and costs are often negotiated in the patent purchase agreement. It's not unusual for the seller to be retained on an hourly rate plus expenses if the seller's participation in the lawsuit is necessary to assert the patents against infringers.